Hello and welcome to episode 99 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh DeHaas, counsel with the Canadian Constitution Foundation.
And I'm Christine Van Geyn, the CCF's litigation director.
I'm Joanna Barron, the CCF's executive director. It's good to be back after what feels like a long time. I was in the Middle East and Europe and then stuck for a few days in New Jersey, thanks to our national airline. And in today's episode, I'm going to talk about the Lindsay, Ontario home invasion and the current law of stand your ground, or lack of law of stand your ground.
And I'll update you on a big development in our legal fight against the Nova Scotia ban on entering the woods.
Plus, we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to talk about one of the most disturbing acts of censorship that I've seen in Canada in a long time and tell you what I think it says about the sorry state of our free speech law. So, about 3 weeks ago, the mayor of Hamilton, Ontario, that's Andrea Horwath, who almost became premier in 2018, she was leader of the opposition NDP, tweeted that her office had been, quote, made aware of a transphobic ad on a billboard on the Link, which is the Lincoln Alexander Expressway. And while the billboard is not city owned, she wrote, it sits on city leased space and city advertising rules were not followed. We've directed Astral Media to remove it and put stronger safeguards in place. Hate-related incidents are on the rise in Hamilton, but we are also a community that will not stand by when confronted by hate. So within 24 hours of this tweet, she got the billboard taken down. So here's what the billboard actually said. It said, stop medical transitions for minors and let kids be kids.ca, which is a website, and it was just on a plain blue background. And the billboard was created by the Association for Reform Political Action, and it takes you to a website that has messages that say things like a teenager cannot understand the lifelong implications of losing her fertility. Doctors should never cut off healthy body parts from patients whose brains have not fully developed and who are too young to vote or buy alcohol. And other countries are hitting the brakes on medical transition for minors. Canada needs to do the same. And it advertises a Let Kids Be Kids rally coming up at Queen's Park in September. So we really need to think about how Orwellian it is that a group of concerned citizens who are advocating for a policy that, in their view, would protect children from lifelong harm in the least hateful language that you can possibly imagine, were accused by the mayor of hatred, and then a private company, Astral Media, immediately complied with her demand to censor this speech, as if she's some sort of queen or king. And coincidentally, another front of the gender wars also opened up recently in Hamilton, where the father of evidence-based medicine published a systematic review that found evidence for both puberty blockers and hormone therapies in people experiencing gender dysphoria is not high enough quality to say that the treatments either work or that they don't work. And this evidence-based review led to attacks from both sides, from those who deny there's any such thing as transgender people, and those transgender activists who say it's transphobic to even question whether these kinds of therapies work. And I just point this out because it underscores that there's this huge political debate going on right now that ARPA is trying to engage in a very, thoughtful and non-hateful way. And yet we have a mayor that's able to just censor that speech and try and prevent people from seeing their message or attending their rally. Now, I think Horwath might get away with this, probably more likely than not, but it will depend what her lawyers did behind the scenes before she sent out that tweet. So she would be able to do this potentially because so much has gone so badly wrong with our free speech law in Canada, something I wrote a feature article about recently in C2C Journal. And also because our administrative law just allows speech to be balanced against other charter values like equality in a way where claims of equality often win out, and where it really comes down to, in many cases, what the judge thinks about the particular speech. So these battles in the free speech war, where someone tries to buy a bus ad or puts up a billboard that politicians don't like, aren't new, and that means we can already predict to some degree how this is going to turn out. So, for example, in 2018, Hamilton lost a court challenge over removal of a bus shelter ad that featured an image of a man entering a woman's change room with the tagline, "Competing human rights, where's the justice?" And this was from the Christian Heritage Party of Canada. So the city took this down and they lost a challenge to that on the basis of free expression, but only because they didn't, cross their T's and dot their I's and go through the motions of balancing the charter values underlying expression against the charter values underlying equality. So the problem, according to the court, was that they didn't, quote, explain how they had balanced the applicant's rights to engage in political speech versus transgendered citizens' rights to be free from discriminatory speech. So it was an unreasonable decision, but the upshot of that is that they would have been able to censor that ad as long as they, feigned to consider free expression. And that would be consistent with the Supreme Court decision, Greater Vancouver Transit, which found that free expression can be limited on things like bus ads in order to, quote, provide a safe and welcoming environment. And of course, this means there's not going to be any controversial speech allowed, and controversial speech is the whole reason we have freedom of speech protected. You don't need free speech protections for things that everybody agrees with. And so before I pass this over to you for your reaction, Joanna, I just wanted to point out that our dear friend Ryan Alford has a new paper out about this very topic for MacDonald-Laurier Institute. And he gets into all of these problems. And his main theory is that courts have forgotten the true purpose of free speech, which in his view is collectively settling political disputes. So the self-government rationale, and instead they have focused on the truth-seeking or self-actualization rationale, which is more associated with John Stuart Mill. And this is part of what makes it easier for them to censor. And he also gets into how courts have essentially made themselves referees of, what speech is legal and what speech is not by turning to this so-called balancing test. And when they end up balancing stuff, free speech is usually not going to win. So it's an interesting paper. I'll link to it in the show notes. But Joanna, I know you've read about many of these controversies with the bus ads or the billboards. Did this one surprise you?
No, I think this is happening all the time. I mean, it disappoints me, but I think the problem is that moral outrage is used as a shorthand to justify state or state adjacent, in this case, state censorship. And so here you have Horvath, a sitting mayor, on the basis of what she feels is hate, can call for and swiftly receive the removal of a privately funded ad without a court order, without public debate, without even articulating a theory of how this speech constitutes hate is chilling. And I haven't read Professor Alford's paper, but I think it's a really important point. And I'm going to use a phrase that my friend Teresa Bejan said. She's very fancy. She wrote her own book about free speech called Mere Civility that exactly makes this point, that the deepest rationale for free expression is not that the speech, leads to self-actualization or it's good or it's beautiful, but that it allows us to settle disputes about contested topics without killing each other. And she said free speech got flattened into the Procrustean bed of liberalism, meaning the only speech that we tend to think, certainly there's a lot of, precedent for this in Canadian free speech jurisprudence, is, speech that's really nice, speech about like being your truest self. But clearly, this is a polarizing issue in society, in many societies, in our society, across political lines. People have discomfort about the issue of, gender diverse youth and teens and medical interventions. And it's really good that people are having, passionate debate about it, because think about what the alternative is. Look at less liberal societies and how they sort out things like this. I don't know, Christine, you have anything to add?
Yeah, I actually went to the MacDonald-Laurier Institute panel that Ryan Alford did a couple of days ago, which you can watch. They recorded it, so if you want to go and watch it, and it was a really interesting conversation, sort of about the exactly what you just talked about, Joanna, this flattening of the right to freedom of expression, that its origins are in Canadian law, where there's a lot of emphasis on this idea of self-actualization rather than the debate over contested matters of public interest, which is what this billboard is about, obviously. The other thing I'd point out is that this is quite a step further than the bus ad cases. The buses are obviously municipal property. The billboard is on um, property that is leased by Astral Media from the city. So it's like a step removed for the government or for Horvath to try to regulate that, right? That's how she kind of claimed authority. She said that it's on municipal land leased by the billboard company. And I mean, plenty of land is leased from government for all kinds of purposes. And now the government claims that that means that they get to tell you what you can and cannot say on that property. So it's quite a step further and worse than the bus cases, in my opinion. Um, I want to talk now about my news headline, which is an update about our case in Nova Scotia. So, as all of you who listen to this podcast know, we are fighting the Nova Scotia government over their ban on entering the woods. And they imposed this ban on August 6th, and it is in place for quite a long time until October 15th. And it bans just walking in the woods or picnicking, bird watching, walking your dog. And they say it's because there are dry conditions and they are worried about fires. None of those activities cause fires. And our position is to ban fire, not walking. And by the way, when we appeared in court in Halifax yesterday, it was raining. So that's interesting that the ban is still in place. It has been, there's sort of a less restrictive ban in place in Nova Scotia, or sorry, in New Brunswick, where it also rained, and they've repealed that because it rained, but it's still in place as of this recording in Nova Scotia. Um, so when this happened back on on August 6th, we announced that we would be seeking a judicial review of this proclamation because it violates the charter. There's actually a possibility of a term of imprisonment for walking in the woods, in addition to the $25,000 fine. And because we say it's actually outside the scope of the government's authority to issue a proclamation this broad and arbitrary. But the government actually does not want our judicial review to be heard. Yesterday in court, in Halifax, the Nova Scotia government tried to stop us before we even started. Their lawyer argued that the CCF shouldn't be allowed to bring this case because we don't have standing as a public interest litigant. And they essentially called us a come from away, saying that we are not based in Nova Scotia and we cannot represent Nova Scotians. That did not stop us. We have heard from hundreds of people, actually thousands of people across Canada, including many Nova Scotians who oppose this ban. So we're really proud to fight for all of these people in Nova Scotia. And there is actually a test for when an organization like the CCF can be granted standing as a public interest litigant. And it comes from a case called Council for Canadians with Disabilities in British Columbia. And in fact, we know a lot about this test because we were an intervener in that case at the Supreme Court of Canada. And so there are three factors that the court considers in granting public interest standing. First, there's a serious justiciable issue. Second, does the applicant have a real stake or genuine interest in the case? And third, is the proposed approach of a public interest litigant in all circumstances a reasonable and effective way to bring the issue before the court? So the first and second questions, serious issue and genuine stake, like not really in dispute. It's really the last factor that was kind of the government's issue in this case, whether or not this is a reasonable and effective way to bring the issue. But they kind of misunderstand the law, the government. This factor doesn't require that this be the preferred way. I mean, the government doesn't get to pick their ideal opponent. It just means, is this reasonable and effective? Which of course it is. We are an experienced public interest litigant. And the government tried to argue that we actually shouldn't have standing, citing two cases, both from Ontario lower courts, one from the 1990s and one from 1989, both in a criminal law context. As soon as I heard this, it's like, give me a break. The Supreme Court has set out this test in 2022 in the Council for Canadians with Disabilities. Even if those old Ontario cases were relevant, which they aren't, they're criminal law cases, the new Supreme Court case from 2022 supersedes them. So, very ridiculous claim to cite these cases. So, as a result, the Supreme Court of Nova Scotia agreed with us. They granted us public interest standing. We're going to have written reasons for this to follow, which is great. It helps us in future cases where we seek to be a public interest litigant. And now we're moving forward on behalf of every Nova Scotian. So I just want to reiterate another thing that the government argued in this hearing yesterday that is absurd. So if you might know this, but in 2023 there was a Nova Scotian man named Jeff Evely, and he tried to challenge a sort of similar ban to walking in the woods in 2023. In that case, the government argued that Evely didn't have private standing because he didn't have a ticket. But now, when we, the CCF, try to bring this case, they say we don't have public standing. So basically, they don't think anyone has standing. Their position boils down to no one should be able to challenge them at all, and they should be immune from review. So, thanks to yesterday's decision giving us standing, they will not get that immunity that they want. The next step in this case is there's going to be a motion for date and directions that will set the date for the full hearing, and we will get to see the government's record and hold them accountable in court. That motion for date and direction will take place on September 2nd, so about a week from now, and I'll give you an update when it's done. We might not update on the podcast, so if you want to make sure you get that update, you have to subscribe to our email list, which is at the ccf.ca/freedom updates. And I think I might have mentioned this before, but we do need to raise a lot of money for this case. It's going to cost us about $40,000. And actually, we've already raised about half of that. We've raised just over $20,000 so far for this case. So if you believe in this, please go to the ccf.ca/donate, and you can select this case to make a donation towards. So thanks to everybody who listens, who already donated. And if you care about this, please consider donating as well. Josh, you were there in the hearing with me. What did you think of the government's argument?
Well, I'm going to try and be nice here, Christine, because it's good professional practice. The part where you point out that the government pulled out these 1989 cases, and their point they were trying to make was that if there's a parallel criminal proceeding, the other case, the judicial review in Superior Court, or I guess Supreme Court as it's called in Nova Scotia, shouldn't go ahead. Well, these were obviously, as you pointed out, criminal cases, not quasi-criminal cases, and what we're doing is a judicial review. It's not a charter challenge that could be challenged on the criminal case if it were to go ahead, or the quasi-criminal case like someone with an actual ticket. So it wasn't a good argument, but the best part for me was I heard him say that, and I thought, oh no, he's going to have some great case that establishes this, and then we might be in trouble. And then the judge immediately said, "Do you have an authority on that?" And then there was a very long shuffling of papers before he pulled out these 1989 cases. Like it was a lot of suspense in the courtroom, and then it turned out they were something that's been clearly addressed in the Canadian
Very clearly.
Council for Disabilities case, and our excellent local counsel were able to point that out to the judge. So
Don't pull out a 1989 case that has been addressed specifically by the Supreme Court in 2022. Like, what is going on? When I heard
yeah,
it say 1989, I was not worried.
well, I mean, sometimes that can still be valid law, but it's
Not when the
you got to
Supreme Court
read
has already
the
ruled
main.
on it 3 years ago,
Yeah, you got to read the main authority on it that's very recent. So,
which we were
um,
involved in.
yeah, yeah, and anyway, so I'm happy that it's going to go ahead. It's very exciting. one of the most interesting things that happened was right at the end, where the judge asked that when the government come back on Tuesday, that they let the court know whether they'd be willing to waive mootness, because as we've talked about on this podcast, as happened repeatedly during COVID-19, the government would just remove the restrictions before the case could get heard, and then the judges would say, well, this is moot. There's no point in hearing this case because the law is no longer in place. So essentially what that means is the government can violate your rights for, 3 months or 6 months or a year because that's how long it takes to get the case heard. So the judge was basically saying, like, to the government, you should consider waiving mootness in case this can't be heard before this ban is lifted, because this is the type of thing that needs to be addressed on judicial review. These things need to be, the court needs to take a look at this and decide whether rights are violated, or whether the government had the authority to do this. So that's a very good sign, because there's always the risk of mootness, as we know from COVID, repeatedly getting told that it's okay to violate your rights as long as the case can't be heard before they lift the rights violation. So that was sort of the big highlight for me. Joanna, you were in meetings, you didn't attend. What do you think? Are you excited that we're moving ahead?
I'm super excited. Shout out to Nasha and Cherie, our amazing legal team. Shout out to you guys. Yeah, the mootness thing has come up, but that was definitely a very positive signal. And yeah, I'm just glad because sometimes you don't know. We had a good feeling about getting public interest standing, but it's just like they're going to try and lop off the private interest standing guy by resolving his ticket, maybe. And then they say that public interest standing isn't legitimate. So I'm just glad that the court wasn't buying it, because this is a very important case that needs to be heard. Okay, let's take a break and then we'll come back and I will talk to you guys about the home intruder situation.
Just before we take a break, Joanna, I just want to mention the fact that this is episode 99. Next week is our 100th anniversary episode, for which we will be doing an Ask Us Anything. And we do mean you can ask us anything. Doesn't have to be about law. Most of the questions we've got so far are about law, which is interesting. I guess people don't think we're all that interesting otherwise, but we won't necessarily answer every single question, but you're welcome to ask us anything, and we'll do our best to answer those next week. So if you have questions for us, you can email me, jdehawes@theccf.ca. You can post your question in the comments on our YouTube channel, or you can respond to our Freedom Update newsletter that comes out later this week. So now let's go to our break.
Okay, so there is a recent case out of Lindsay, Ontario, which has set off a bit of a firestorm. Police say they were called around 3 a.m. to an altercation after a resident woke to find an armed intruder in his apartment. The intruder was seriously injured, airlifted to Toronto, and the tenant, Jeremy David McDonald, 44 years old, is charged with aggravated assault and assault with a weapon. The alleged intruder, Michael Kyle Breen, 41 years old, is facing separate charges, but we're not going to focus on that. And Jeremy McDonald's lawyer says that he was doing what anyone would do and acted in lawful self-defense. This has become quickly contested and political. Premier Doug Ford said charges here show that something is broken. He said you'll use any force you can to protect your family. And Pierre Poilievre posted that if someone breaks in, you deserve the right to defend, full stop. So I wanted to go through what the law actually is about lawful self-defense, how the Supreme Court of Canada frames it, and share some thoughts. So Canada's self-defense rule is codified in Section 34 of the Criminal Code. This was added in 2012. It was added to modify previous provisions, which said that you could use all necessary force to repel an intruder or defend yourself. This was repealed by the Harper government. And I was just watching a short interview with Bruce Pardy and Maxime Bernier. And Bruce says that this was, a bad change because it made the law less clear. We'll get into that. But I found it more interesting that Maxime Bernier, who was, of course, Justice Minister at the time. Sorry, was he Justice Minister? Anyways, he was involved in this, and his explanation was that at the same time the Harper government was bringing in pro-gun rules, and this was a compromise for the leftist, his terms. So not sure about that. But anyways, let's get back to Section 34. It says in plain English that you're justified if one, you reasonably believe force is being used or threatened; two, you act for the purpose of defending yourself or another; and three, what you do is reasonable in the circumstances. So yes, we should flag right away. That involves a lot of discretion on the part of cops and prosecutors. What's reasonable in the circumstances, and it means that there is uncertainty involved. Parliament does also give courts some guidance on how to judge reasonableness. There's a non-exhaustive list, including the nature of the threat, imminence, other options like retreating or calling police, weapons involved, and crucially, the accused, meaning the person who defended themselves, their role in the incident. Now, the leading case from the Supreme Court on this is from 2021. It's called R.V. Kill, Khlil. And the court stressed in that case that juries should assess reasonableness holistically and consider all of these factors. So an accused's role in the incident includes prior conduct, the run-up, choices to escalate or de-escalate, opportunities to avoid violence, and also prior conduct. So that's the starting point. Another case that I want to mention that sort of was an important case on the development of the law of self-defense is called Lavallee from 1990. And this was a case that was very heavily intervened in, lobbied. There was a lot of pressure from the sort of feminist legal world, like LEAF, the Women's Legal Education and Action Fund, particularly in the context of battered women. So here this was a wife who had been suffering abuse, who I think struck a fatal blow to her husband. And Lavallee stands for the proposition that context matters to reasonableness. So you have to look at the accused circumstances. You can also look at expert evidence. So here there was expert evidence on battered women syndrome that, yeah, maybe that day it wasn't reasonable for Lavallee to think that her husband was going to kill her. But if you look at, the pattern of the relationship, you can see how in her mind it really was. So how is the accused perceiving the danger? There's another case from 2002 called Sinus, which is the error of reality gatekeeping rule. So a defense of self-defense will only go to the jury if there's some evidentiary foundation, there's some error of reality to the perceived threat. So you can see through this that Canada focuses pretty relentlessly on contextual reasonableness, the accused role from beginning to end, and that's before 2012, before the change in the law. So I'm not sure I entirely agree with Bruce that we had this castle doctrine, which I'll get into in a moment, before 2012. So how does this map on to MacDonald? And there are facts that we may not be aware of, but from public reporting so far, MacDonald awoke to an armed intruder in his home. A fight followed. The intruder suffered life-threatening injuries, although wasn't killed. And police is cautioned that when reasonable force is allowed, the right is not unlimited. So continuing to hurt someone who's already subdued can be unreasonable. We're not sure if that's what happened, but it's possible. So they're gonna have to get into the imminence and nature of the threat, the defensive purpose. Was MacDonald acting for protection, or did it shift into something more like retaliation? In other words, was excessive force ruled? And of course, this engages Section 7, procedural fairness, laws and actions that trench on liberty, have to align with principles of fundamental justice. And I think the public reactions, the public comments like Ford and Poilievre's are widely resonating because many of us, including myself, have this castle logic intuitively, right? Your home is your last sanctuary. And if somebody shows up in your home unbidden, particularly given certain circumstances, like, you have the right to stand your ground and protect yourself. but we don't have a statutory stand your ground law. We don't have a blanket castle doctrine. We have this reasonableness test. So even the local police chief emphasized that while you can use force to protect yourself and your property, if you believe that you face a threat, those rights are not unlimited. And so just quickly to compare to the US, in American law, many states codify either castle doctrine or stand your ground rules. Often that includes no duty to retreat. In some places, presumptions in favor of householders who confront intruders. Florida, of course, is the classic example, and everybody knows about the Trayvon Martin case. A person has no duty to retreat in a dwelling, and they may stand their ground if they reasonably believe deadly force is necessary. So Canada is quite different. We go to what are the possible other means, and it's not an automatic bar or shield. We have this quote unquote holistic reasonableness review. So my thoughts on this, I actually kind of came around. So I actually think the current law is reasonable. And I actually don't think the shift from you can use all force that is necessary to you can defend yourself reasonably in the circumstances according to your own perception. I think it's kind of just a matter of semantics, because let's say you subdue someone, somebody breaks into your house, you knock them out. Let's say, theoretically, I clearly wouldn't be able to do this. You knock them out, they're unconscious, they're lying on the floor unconscious, and you continue to kick them in until they die. That's clearly going beyond the force that is necessary to subdue the threat, I would argue. So I think this is a matter of semantics. I think it's true that we don't want to encourage people that, like, if somebody shows up at your house, I don't know, and they're like a political marketer or something like that, you get freaked out and you can kill them. I don't think that's something we should spread in society. I think that you should use what force is reasonable in the circumstances, which in some cases may be deadly force. In some cases, you have every reason to go to the worst case scenario. Cops aren't going to get there in time. But I also see that people are really concerned about the lack of clarity. But I would just say, don't be worried. Like, if you stick to your reasonable instincts, you're probably going to be okay. We don't know all the circumstances of this case. Christine, I know that you were talking with some family friends about this week. Anything to add?
One thing I would say is, I don't think you mentioned this, but the reporting that I've seen subsequently has a little bit more detail. It's reporting from the Rebel, and I don't know why others have not reported on this, but they have. And what they have reported is that the burglar person was in the apartment with a crossbow.
Mm-hmm.
That the general reporting is that he had a weapon, but we don't know what weapon it was. So, a lot of things could be considered a weapon, but a crossbow, I would say, is like a pretty serious weapon. And finding a man in your kitchen at 3 in the morning with a crossbow, I think, that to me would constitute a lethal threat.
Mm-hmm.
And he responded with a knife. Apparently he had the homeowner, the resident, attacked him with a knife. The thing I would say about the law, which I think you've laid out well, is that it seems to be set up in a way that is like designed to protect the risk of a burglar or person entering the home of an absolute psychopath. So, like, it just seems like a not realistic scenario that a person, dropping off political literature, knocks on the door of an absolute bloodlusty psycho who wants to stab them to death. And I just don't know that that's the right way to frame the law. I suppose there's some like political, or sorry, some scenario in this case where there's a possibility that the resident and the burglar like perhaps knew each other and had some pre-existing dispute, in which case this that led to the charges. We just don't know what the facts are here, and that he, like used it as an opportunity to murder someone who he already knew and didn't like. But I think that really we need the information. Like
Yeah.
we need the facts from the police. Like the way this is being portrayed is a man was asleep and found a burglar in his home with a crossbow, and he defended his home because he thought he was going to die. If the scenario is actually this, wildly unlikely hypothetical that this burglar broke into the home of a psychopath who wanted to murder anyone he could find, even if he was already unconscious on the ground, the police should tell, like, we should know that. And I wish there would just be more information at this point. Because like it's weird that there hasn't even been broad reporting that he had a crossbow. Like, why aren't we being told that? Josh, what do you have to add there?
Yeah, I mean, if there was a crossbow involved, if it was really crossbow versus knife, and just emphasizing again that this is all not confirmed. It's out there, but it's not confirmed. If that's the case, then I can't imagine many scenarios where there should have been charges. And so, while the law might be right, like as Joanna walked through, the law is probably pretty good on this. The problem is that, some police officer thought I should consider charging this person, almost certainly consulted with a local crown because it's not the type of thing where the police are just going to charge without, asking some questions to the crown. And they went ahead with it. So if facts really are what's out there, then the problem is not necessarily the law, it's that somebody was charged rather than the crown using their discretion to not charge. And I also just want to point out, I think it's funny that we're having this conversation when Lavallee, the case Joanna mentioned briefly, went all the way to the Supreme Court because in Lavallee, what happened was it was actually shooting Joanna. So it was a woman who had been beaten regularly by her partner, and it's really, really sad facts. And they got into a big fight, and the man handed Ms. Lavallee a gun, and she fired it through the window screen. And then he turned around to leave and started exiting the room, and she shot him in the back of the head. And she was acquitted, and she was acquitted on the basis of a new social science concept that seems to have been created essentially for this case by the expert witnesses, called battered women syndrome, where women are so afraid after they've been, beaten regularly by men that they might feel in their head reasonably that if they don't shoot a man in the back of the head as he's exiting the room, that they will eventually be killed. And because of that mental condition, she was acquitted. I think I actually don't agree with the outcome of that case. It's an unpopular opinion. I said that I didn't believe in battered women syndrome once at an event when I was an articling student, and a few of my fellow articling students got up from the table and left and never talked to me again. There was some crying and hugging involved because I dared to say I didn't think battered women syndrome was actually a real thing. So anyway, but yeah, the issue here at the end of the day is not necessarily our law. Our law is often better than it first appears on this stuff because it's developed over decades, and there's a lot of smart people involved in figuring it out. So the issue is in this case might just be that charges were laid when they shouldn't have been. So I guess we should move to our bad legal takes unless anyone has anything else to say about that. Christine, do you want to go first?
Yeah, sure. My bad legal take this week goes to the CBC, which is using our money to go to court to fight a disclosure order. So had been a request made by an assistant professor at University of Ottawa named Matt Malone, and he asked for the numbers of subscribers to CBC Gem, which is CBC's online streaming service. It is free, but you can subscribe for an ad-free version with the same programming for $5.99 a month. So Professor Malone filed a Freedom of Information request, and CBC refused it. And they said this is competitive information. So Malone appealed to the information commissioner who sided with him and ordered a disclosure. And that was back in July. Now CBC is fighting that order in federal court. So they would rather use more of your money, your taxpayer dollars, to go to court and fight this order rather than being transparent with disclosures. And I think we probably all know why they are refusing to disclose their number of subscribers. I don't think it's because they believe this is competitive information. It's probably that it's embarrassing how few paid subscribers they have. So my friend Franco Terzano from the Canadian Taxpayers Federation posted on X that CBC probably has more managers at GEM than they have subscribers. And you know what? He's probably right. So CBC fighting this disclosure order with our money and against our interests is my bad legal take of the week.
I'll go next since mine also has to do with CBC. And, I love your bad legal take, by the way, Christine, because as you know, I used to work in news, and CBC was notorious for very jealously gardening its ratings in a way that the private broadcasters weren't, although the private broadcasters' ratings were often also really bad. Certain shows, if it was under 15,000 viewers estimated, you wouldn't even get ratings. And there were many shows that regularly did not meet that 15,000 viewers in the entire country number to get rated. So my bad legal take goes to CBC, PEI in particular. As listeners probably know by now, we lost our motion in the John Robertson matter to extend the time for judicial review, which means that that case is that the sanctions for now will stand against John Robertson, even though the judge did say in the case that it was an understatement to say that we had a reasonable case on the merits. So had John been able to make that 30-day deadline originally, pretty good chance he would have won. So in some negotiations there, but the funny thing is the CBC has consistently made really embarrassing factual errors in their coverage of this story. They just cannot seem to get it right, and it would not be hard for them to get it right by, for example, talking to me. In the latest article they've written about it, which makes it, fails to mention the fact that this was found to be a reasonable case by the judge, even though it was dismissed for the delay. They say the court's decision not to grant retroactive extension to the filing time effectively means Robertson's quest for judicial review is over unless he seeks leave to the Supreme Court of Canada. So I don't know what makes this person think that you can appeal from a local Prince Edward Island court directly to the Supreme Court of Canada, but you can't. And that's something kids should learn in high school, I would say. And that's why people should consider going onto our website and checking out our new high school course packs, which have an entire lesson on how judges are appointed and which levels of court do what, something that high school students should all know, and journalists certainly should know before they write stories saying that you can appeal a local decision to the Supreme Court of Canada. So my bad legal take also goes to CBC.
Okay, my bad legal take goes to the city of Vancouver, which has discovered a bold new category of hazardous activity that needs to be regulated. Parents showing their children how to float at public pools, the horror. So a mom at Kensington Pool spent 20 minutes doing glides with her daughter in the shallow end. The lifeguard decided that it looked a little too much like a lesson, and suddenly mom was cast as an unlicensed intruder swim mogul. So the Park Board of Vancouver's own page says you can't train or instruct, including private swimming lessons, unless you are a registered private business. There's even a one-pager that says all swimming lessons, including both group and private, are delivered within the operation of the Park Board. It says that parents are welcome to support and guide their children, but organized and structured private swim instruction is banned unless it's an approved business. So the interpretation of this clearly is if it's anything that looks too pedagogical, once you cross that line, it's banned. So this is a bad legal take. It's confusing commerce with parenting. I guess it was written to stop unvetted paid instructors from running shops and public facilities. Whatever you think about that, that's very different from a mom and 7-year-old doing bobs in the shallow end. It's vague in application. It would not be justified in a post-Vavilov world where decisions must be justified by intelligible reasons tied to the statute or policy's purpose. It also undercuts the safety rationale. It claims it's not even consistent against Metro Vancouver. Some municipalities like Surrey and North Van explicitly allow parents to teach during public swim if they follow their rules. Others restrict the lessons to city staff. Bottom line is that parents practicing floats with their kids is not some sort of black market aquatics ring. And if your safety policy requires a business license to do kicks in the pool with your kid, the policy is the issue, not the parent.
But Joanna, since this is the Vancouver Park Board, obviously you can still teach your kids how to like roll a joint in the pool or
Obviously,
smoke fentanyl,
that's
right?
basic life skills.
All right. Well, that's the show. As usual, we hope you'll rate us, review us, and subscribe if you haven't already. We still have a stellar 4.8 review on Apple, which is great. So only review us if it's 5 stars. You can support our work by subscribing to our YouTube channel, by following us on X, by visiting our website, and donating to our Nova Scotia Challenge if you can afford to give. And you should sign up for our Freedom Update newsletter if you haven't already. The CCF is a nonpartisan legal charity funded by your donations, so please do donate on our website if you can. Thanks for listening.